If any members of the gallery wish to depart, I ask that you do that now. Parties, I ask your assistants, can we put the door somewhere other than right there? And I don't know if y'all need gloves. If you want to lay it down, that's fine. I just don't want to have it in the field of view while I'm reading instructions. Thank you. Members of the jury, I trust that you are comfortable for the next 20 to 30 minutes. Is that a fair assumption? Thank you. Thank you to the parties. I appreciate your assistance. Thank you. Give everyone about 20 seconds more. You are considering the case of the state of Georgia versus Suzanne Mericle. A grand jury has indicted the defendant with 1 count of malice murder, 2 counts of felony murder, 1 count of aggravated assault, and 1 count of criminal damage to property in the first degree, 1 count of possession of a firearm during the commission of a felony, and 1 count of tampering with evidence. The indictment reads as follows. Count 1. In the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of malice murder. 4, that the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did unlawfully and with malice aforethought cause the death of James Barron, a human being, by shooting him in violation of Official Code of Georgia 16-5-1 parentheses A close parentheses contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. In the grand jurors aforesaid, in the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of felony murder. For that, the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did, while in the commission of a felony, to wit, aggravated assault as alleged in count 4 of this indictment, caused the death of James Barron, human being, in violation of Official Code of Georgia 16-5-1 parentheses C close parentheses contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid in the name and on behalf of the citizens of the state of Georgia charge and accuse Suzanne Mericle with the offense of felony murder. For that the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did, while in the commission of a felony, to wit, criminal damage to property in the first degree as alleged in count 5 of this indictment, caused the death of James Barron, human being, in violation of OCGA 16-5-1 parentheses C close parentheses contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. The grand jurors aforesaid in the name and behalf of the citizens of the state of Georgia charge and accuse Suzanne Mericle with the offense of aggravated assault. for that the said accused in the county of Hall and the state of Georgia on the 8th day of March 2025 did assault another, to wit, James Barron, with a deadly weapon, to wit, a firearm, which when used offensively against a person is likely to and does result in serious bodily injury by firing said weapon through a door in the direction of James Barron in violation of OCGA 16-5-21, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid, in the name and in behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of criminal damage to property in the first degree. 4, that the said accused in the county of Hall and the state of Georgia on the 8th day of March 2025 did knowingly and without authority interfere with a door in a manner so as to endanger human life by shooting the door of a room that was occupied by a person, to wit, James Barron, in violation of OCGA 16-7-22, again 16-7-22, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6. The grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of possession of a firearm during commission of a felony, for that the said accused in the county of Hall and the state of Georgia on the 8th day of March 2025 did have on her person a firearm, to wit, a handgun, during the commission of a crime, to wit, aggravated assault, as alleged in count 4 of this indictment in violation of OCGA 16-11-106, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 7. The grand jurors aforesaid, in the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of tampering with evidence, for that the said accused in the county of Hall and the state of Georgia on the 8th day of March 2025 did knowingly conceal physical evidence, to wit, shell casings and bullets, with intent to obstruct the prosecution of said accused in violation of OCGA 16-10-94, contrary to the laws of said state, the good order, peace, and dignity thereof. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent unless and until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in the defendant's favor. This presumption remains with the defendant until it is overcome by the state with evidences sufficient to convince you, beyond a reasonable doubt, that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should find the defendant not guilty. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to find the defendant not guilty. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is a testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. To impeach a witness is to show that witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1. The defendant had a right to remain silent. 2. If the defendant chose to not remain silent, anything she said could be used as evidence against the defendant in court. 3. The defendant had a right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And 4, If the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questions. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or part of such evidence. If you fail to find that the defendant was properly informed of these rights and that she understood and gave up, If you fail to find the defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. Evidence of prior difficulties, or lack thereof, between the defendant and the alleged victim or a witness has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim or witness, or the reasonableness of any alleged fears by defendant or alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. This defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act or omission to act and intention. When the indictment charges that a crime was committed in more than one way, the state is not required to prove the commission of that crime in every way, but may prove the crime was committed in any of the ways charged. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Criminal negligence is an act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Hall County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt. As to each crime charged in the indictment, just as any element of the offense or offenses, venue must be proved by direct or circumstantial evidence or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe, beyond a reasonable doubt, that the defendant in Hall County, Georgia, did, on or about March 8, 2025, commit one or more of the offenses of malice murder, felony murder, aggravated assault, criminal damage to property in the first degree, possession of a firearm during commission of a felony, and or tampering with evidence as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. For each count, you find the defendant guilty. If you do not believe that the defendant is guilty of any or all of the offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. For each count, you find the defendant not guilty. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, without excuse, and without mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Felony murder. The state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. Criminal damage to property in the first degree is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault and or criminal damage to property in the first degree, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. In considering the malice and felony murder charges in counts 1, 2, and 3, you must first decide whether the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of malice or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. The defendant may not be guilty of malice murder in count 1 or felony murder in counts 2 or 3, but still guilty of voluntary manslaughter. For voluntary manslaughter, the evidence must prove that the defendant, 1, caused the death of another person, 2, under circumstances that would otherwise be murder, 3, and acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, 4, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. If you find that the defendant acted under such provocation and passion as would authorize a verdict of voluntary manslaughter as to count 1, you would not be authorized to find the defendant guilty of felony murder based upon that same aggravated assault as to count 2, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of voluntary manslaughter as to count 2 and or count 3. If you find that the defendant acted under such provocation and passion as would authorize a verdict of voluntary manslaughter as to count 2, you would not be authorized to find the defendant guilty of malice murder based upon the same aggravated assault as to count 1, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of voluntary manslaughter as to count 1 and or count 3. If you find that the defendant acted under such provocation and passion as would authorize a verdict of voluntary manslaughter as to count 3, you would not be authorized to find the defendant guilty of felony murder based upon the same aggravated assault as to count 2, or that same aggravated assault as to count 1. You would, however, be authorized to consider whether the defendant is guilty of voluntary manslaughter as to count 1 and or count 2. Words alone no matter how provoking, will never reduce the crime from murder to voluntary manslaughter. However, words coupled with menacing actions, even if they do not amount to physical contact, may be enough to excite a sudden, violent, and irresistible passion in a reasonable person. If you find that the defendant acted from such passion and not from malice or any spirit of revenge, then you would be authorized to return a verdict of guilty of voluntary manslaughter. The defendant may not be guilty of malice murder in count 1 or felony murder in counts 2 or 3, but still guilty of involuntary manslaughter. 4, involuntary manslaughter, the evidence must prove that the defendant, 1, caused the death of another person, 2, without intending to, 3, by committing the offense of reckless conduct. If you find that the defendant acted without such intent as would authorize a verdict of involuntary manslaughter as to count 1, you would not be authorized to find the defendant guilty of felony murder based upon that same aggravated assault as to count 2, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of involuntary manslaughter as to count 2 and or count 3. If you find that the defendant acted without such intent as would authorize a verdict of involuntary manslaughter as to count 2, you would not be authorized to find the defendant guilty of malice murder based upon the same aggravated assault as to count 1, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of involuntary manslaughter as to count 1 and or count 3. If you find the defendant acted without such intent as would authorize a verdict of involuntary manslaughter as to count 3, you would not be authorized to find the defendant guilty of felony murder based upon that same aggravated assault as to count 2, or that same aggravated assault as to count 1. You would, however, be authorized to consider whether the defendant is guilty of involuntary manslaughter as to count 1 and or count 2. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon or an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. A person commits the offense of criminal damage to property in the first degree when she knowingly and without authority interferes with any property in a manner so as to endanger human life. The term without authority means without legal right or privilege. The defendant may not be guilty of aggravated assault in count 4 of first-degree criminal damage to property in count 5, but still be guilty of reckless conduct. For reckless conduct, the evidence must prove that the defendant, 1, caused bodily harm to another person, 2, by consciously disregarding, 3, a substantial and unjustifiable risk, 4, that the defendant's act, 5, would cause harm to the other person. A conscious disregard must arise to the level of a gross deviation from the standard of care a reasonable person would exercise in the particular situation. For possession of a firearm during commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on her person, 3, while committing an aggravated assault. For purpose of this offense, a firearm includes any handgun. A person commits the offense of tampering with evidence when, with the intent to obstruct the prosecution of any person, she knowingly conceals physical evidence. The defendant has raised a defense that even if she committed the act described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. If a defendant's conduct is justified, that is a defense to any crime based on that conduct. Sometimes a defendant's threat or use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, she reasonably believes that the use of such force is necessary, 2, to prevent A, death or serious bodily injury to herself, or B, the commission of a forcible felony, which means a felony that involves the use or threat of force or violence against another. Aggravated assault by strangulation, aggravated sodomy, and malice murder are forcible felonies, each of which I will define for you shortly. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. Aggravated assault by strangulation is an attempt to injure another person with anything when used offensively is likely to or does result in strangulation, including one's hands. Strangulation means blocking or interfering with another person's normal breathing or blood circulation by either 1, applying pressure to the person's throat or neck, or 2, obstructing the person's nose or mouth. Sodomy is any sexual act that involves the sexual organs of one person and the mouth or anus of another. Aggravated sodomy is an act of sodomy that is both forcible and against the will of the victim. An act is forcible if it is accomplished through acts of physical force, threats of harm, or intimidation. An act is against the will of the victim if it does, I repeat, an act is against the will of the victim if it is done without the victim's consent. For the defendant's threat or use of force to be justified, 1, the defendant must believe that her threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary, and the defendant's reasonable belief must be what prompts her to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force she reasonably believes to be necessary. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone, if the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger. The defendant is in imminent danger of serious bodily injury, or a forcible felony is about to be committed. Then, the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing actions may justify the use of deadly force. A defendant is not justified in using excessive force while acting in self-defense. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. A defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing an imminent commission of a forcible felony, then you would be authorized to convict the defendant. A forcible felony is a felony that involves the use or threat of force or violence against another. Aggravated assault and aggravated sodomy are forcible felonies and will be defined for you shortly. If a defendant raises as defense justification using force against another, you may consider relevant evidence that the defendant has been subject to acts of family violence or dating violence in order to establish the defendant's reasonable belief that deadly force was immediately necessary. Family violence means the occurrence of one or more of the following acts between persons living in the same household. 1, any felony. Or 2, commission of offenses of battery, simple assault, stalking, criminal damage to property, unlawful restraint, or criminal trespass. Dating violence means the occurrence of one or more of the following acts between persons who are currently or within the last 12 months were in a dating relationship. 1, any felony, or 2, commission of the offense of simple battery, simple assault, or stalking. Dating relationship means a committed romantic relationship characterized by a level of intimacy that is not associated with mere friendship or between persons in an ordinary business, social, or educational context. Voluntary intoxication is not a defense to a crime. If the defendant, when sober, could reason and distinguish between right and wrong, and she voluntarily became intoxicated and then committed a crime while intoxicated, she is responsible for the crime just as if she had been sober at the time she committed the crime. Members of the jury, by no ruling or comment that the court has made during the progress of this trial has the court intended to express an opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. You are only concerned with guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as a foreperson who will preside over your deliberations, and he or she will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of opinions of other jurors. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. You will have with you all the evidence which has been introduced at trial. Additionally, you will have a copy of the indictment, this charge of law, and the verdict form. This has been displayed, making no comment on that display, but you will have a copy of the verdict form. You will mark your verdict for each and every count, marking one and only one option per count. It will then be signed and dated by your foreperson. Once you have that verdict, please let the bailiff station outside your door know. We will get you into court as quickly as possible in order to take that verdict. In a moment, you will retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence which has been admitted in this case. During that time, you may proceed to select one of your foreperson as your foreperson. Other than previous objections, any reading that y'all would like to discuss? If you do, approach.
Generally, it's written this type.
Everybody makes mistakes, including judges. I'm going to reread one charge, and just because I'm reading it doesn't mean I'm necessarily focusing on that, but I do want to make sure that it is correct. This is in relation to causation in felony murder. I'm going to reread it. You may find the defendant guilty of felony murder if you believed that she caused the death of another person by committing the felony of aggravated assault and or criminal damage to property in the first degree, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of whether the death ultimately occurred. Good?
Yes, Your Honor.
I apologize for that. Any other reading things we need to discuss?
Not from the state judge.
Nor from the defense.
Folks, I'm aware that it's 1:10. You are going to control your own schedule. There are currently 14 of you. I will discuss with the two alternates. They've not done anything wrong. All 12 of you will deliberate. If someone needs to take a break, you all take a break. You cannot start without somebody. So if somebody disappears on us, then we'll restart with an alternate. You will control your schedule. So certainly want y'all to make a reasonable effort at it. If you would like to go break for lunch now and come back, y'all figure that out. If you would like for the county to purchase lunch for you while y'all work, we can make that happen. That's an either or. So we're going to leave it to you. The attorneys and I have discussed the door. We will move that into your jury deliberation room. If y'all do not want it there, let one of the bailiffs know and we'll work on getting it out, et cetera, et cetera. Making no comment one way or the other, you will have with you all the evidence as well as gloves, if appropriate, regarding handling. You will not have with you a computer or some way to play video and or audio. So if you, I'm not saying you should or should not, but if you do desire to do that, you'll have to affirmatively request and then we'll bring it out and play it, etc. With that, I will leave you to go deliberate. I will briefly discuss with the two alternate jurors, Eubanks and Render, please. Everyone else can go to the deliberation room. We will need a decision on whether you want to break. You can take breaks, just give us the